Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations, and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
So I hope that was informative about telling you about our services. Evan Kleekamp, I'm excited to have you talk to us about Indisputable Defense.
Hi, everybody. Today's chat is titled Indisputable Defense, which is just this kind of principle that I'll elaborate throughout the course of the talk today. And so I would say the primary objective here on the very literal level is to prepare for small claims court. What I'm going to try to tell people today is that it's kind of like an ongoing process, and that maybe it's best to kind of assume that one is going to have to go to small claims court someday. And this is just a short note I wrote in my journal maybe like 2 years ago that I keep coming back to, which is simply something along the lines of like, people who use the law in up ways deserve the law to with them, or deserve the court system to with them. And I'll come back with that later. But that's just the kind of piece of attitude that I wanted to bring to the talk today. A little about me. Well, I can start with NOR. So NOR is the research studio I operate. Essentially, I create intellectual property for artists, independent media workers, and nonprofits and media startups. I do a lot of ghostwriting, a lot of grant writing and contract writing. Occasionally, I do crowdfunding campaigns. Some kind of recent brags is I help my clients get a California Arts Council grant, and I wrote some applications that were awarded finalist status for Creative Capital and Andy Warhol Foundation, as well as the Sundance Institute New Frontier Lab. A little about me: I'm autistic. I live in Los Angeles. I make art. Sometimes I make book art. Sometimes I make physical art, and I have a cat. He'll probably also end up on the screen. Small claims court. I want to start by differentiating small claims court from the broader legal system. Small claims court is a very specialized court. It's usually like handled on a very local level. It's a regional court. Some disclaimers, basically, too. I'm not a lawyer. I don't want necessarily to make anyone feel as though I have the expertise of a lawyer. I wholeheartedly believe the court system is Byzantine and hard to navigate. And I assume that most people who get in situations where they have to go to small claims court are going to be stressed out. If you are actually hoping to file any kind of lawsuit, you should be prepared to spend months preparing your case. Most people are going to settle out of court because the courtroom is kind of a nasty place. It's stressful to get there. You have to take time out of your day. It's a lot of work, and it's not always very rewarding for either party. And then this is a strategy talk. It's not a walkthrough. So I can't, in the space of an hour and a half, go through every aspect of small claims court. That'd be too difficult. But essentially, it's a really complicated thing. And there's no way for me to prepare someone on an individual level to handle any court case that falls in their lap. Like I said, though, small claims court is a specialized court with limited jurisdiction. The court is only going to hear cases that involve damages that are equal to or less than $10,000. So basically, it's often going to be like a freelancer who's trying to get paid. It might be a landlord or a renter in a dispute, or maybe a dispute between you and your friend about like a car accident that happened in the driveway, stuff like that. Some additional context: there's no juries. You're not trying to convince anyone other than a judge. There's no lawyers. You can't, in the courtroom, you can't have the support of a lawyer. You have to represent yourself. There's a limited window you have once you filed the claim, or when you file this form that says that you want to sue somebody. And there are also some kind of bumpers around the statute of limitations, meaning that if you have a dispute happen that involves a written contract, I believe you have a 4-year period to try to reconcile that through the court. You're going to pay a little bit of money to file the claim, and also you're going to pay money if you want to hire somebody to serve the papers to the person you're suing. You have the option of using a local sheriff or a service agent, which I recommend depending on your situation. I think the service agents are pretty great. They're pretty affordable. They're usually less than $100 unless you have a really, really gnarly defendant that you're trying to track down, or the person you're trying to sue. And as always, keep your legal fee receipts. So if you have to talk to a lawyer to consult them, you need to pay them. If you need to hire a service agent, or if you pay any person to kind of help you with these things, keep those receipts in place, because it's very likely that the person you're suing, if you succeed, will have to reimburse you. I think the thing that I want people to walk away with after this talk is this kind of understanding that, like, though you might get a little bit of sympathy from a judge in a small claims court case, the legal system is ultimately not that concerned. The reason why it's called small claims is because the court, as I'm about to say, basically considers $10,000 to be like an insignificant amount of money. So there's all these kind of elaborate processes that you're going to go through to prove to the court that you really, really, really desperately want this money. And the better job you do of showing that that desperation is not because you are having some kind of emotional dispute with the other party, but because you are just practicing business and you're trying to maintain a kind of professional decorum, the more successful you'll be. So kind of just to start, like, it's really important, if you're going to sue somebody, you have to be able to maintain good faith communications and be meticulous in your record keeping. You will probably enter a situation where you will no longer be talking to that person directly, and I'll get into that in a bit. But in the situation where, for example, you're making your first kind of reminder email that you're owed money, do not come in there hot. You want to just be very calm, very plain spoken, and say, like, hey, I'm writing to you about this money that I believe is owed to me. Here's the reason why I think I'm owed it. When do you think you can pay me? That kind of stuff. We want to keep it very neutral, very professional. Like I said before, the court doesn't consider small claims cases a priority. And so they want you to settle out of court if possible. And they also, if it ends up in the courtroom, they want to solve it quickly. And so if you play into that kind of strategy, if you understand that you're just trying to get things in and out, and you prioritize your argument, what you're saying to the court, and the evidence that you've gathered to make that point, things will go much easier and very likely end in your favor. You do not want to be the person who is unorganized, who's an inefficient communicator, who is basically given the judge reasons to ask a ton of questions. We want to aim towards this point where everyone is on the same page and things are quote unquote indisputable, meaning that no one is going to try to argue against it. And again, we'll build to that point. And just as a kind of baseline rule, you are just there to get money you are owed. It's nothing personal. Okay, so the first part of this process, assuming that you've already kind of began this dispute with a client or maybe an employer, who knows. Where we're at now is just assuming that you've already arrived to this point of acknowledging to yourself that you're going to probably have to sue this person. You probably have already had some kind of either heated debate with them or misunderstanding about the money you're owed, and you are using the small claims court to reconcile that dispute or resolve it. And so essentially there's like 5 pieces of this equation that are, for the most part, like going to happen. You're going to need to do them. You're going to need to be aware of them. And maybe the exception there is the hearing date if you settle out of court, but you still need to kind of pay attention to when that date is happening, because you have a limited amount of time to resolve your case before it goes to court. So that's just the kind of window you have to operate with that. The demand letter is pretty much exactly what it sounds like. You need to communicate in writing to this person that you have a dispute with that they owe you money, and you need to give them the opportunity before the court case ever manifests to just pay you or to otherwise resolve the dispute. If you don't do that, the court basically will say it's not fair. You never gave them the opportunity to fix this without us getting involved. And so they will more than likely throw out your case. And if you go online, especially if you're in Los Angeles or any of these other kind of California cities, if you go onto the local small claims court, they have individual websites. You can find a template that they provided that basically is a form letter, and you enter like where you live, where this person lives, or the business they operate. You quickly say what you're owed, why you're owed it, when you expect payment, and how you expect to be paid in that letter. And the reason why we recommend using a template is simply that people see that template and they get a bit scared. Most people don't want to go through the ordeal that is just legal problems, and then from there having to go to court to solve those things is usually not what they want to do. And so it's best to use that in their favor. One thing you definitely want to do in that letter is indicate that you have the intention of going to court. That's not just there for the sake of kind of threatening them, but you also want to let them know factually that like you are prepared to gather the materials to enter that dispute, and that they should do the same. So we're going to talk about evidence in a second, but basically that letter is the first piece of evidence that you need to be prepared to show in the courtroom. form. The demand letter is basically your first formal attempt to receive payment, and it's showing that you are trying to communicate peaceably, neutrally, and professionally with that opposing party or client. And so you're giving them the opportunity to kind of solve this problem before it turns into something much bigger, larger, and scarier. It's really important to get your kind of claim down to about 2 to 3 sentences. So you're just saying, I am owed this much money by this person for work I did on this project during this time. If you can, include timestamps, so give a kind of clear indication of when these things are happening. And that stuff will all become more and more material as your dispute kind of grows. This is an example of the form letter. And so this part in purple was the only part of the letter that I actually had to spell out. And I made a tiny mistake that typically would get your hand smacked by the court. I accidentally put CAC as opposed to CLA. And of course, this is just a joke. And so basically, you can go online, you enter all the information that you see here, like the California Lawyers for the Arts, you enter the address. I didn't put a name here, but the person who is responsible for receiving basically legal mail for the business or the individual, that's where their name would go at that attention space. And also right here at the Dear Mr. All this language that you see beneath the purple is automatically populated by this kind of template. And as you can see, it has a very like legally jargony kind of tone to it. And it's supposed to be there to indicate to this person that, this is a serious complaint. One of the other options you have in the form letter is kind of letting the person know how you're going to send this letter. So you can email it to them, you can send it to them via first class mail, whatever way you have of communicating with that person that is neutral and not going to lead to kind of tension between you two. And then the next piece of the equation is the SC 100 form. It just means small claims 100. It's the basic form that everyone's going to file when they are making a small claims complaint. So I'm not going to spend a lot of time on this form because like many of the things that are involved with filing a kind of complaint or getting your case to be seen by the court, it's paperwork, right? And so as you might expect, you're going to be filling a lot of just like, here's my address, here's the address of the person I'm suing. So up here is the plaintiff space. That is where you, the party that would be doing the suing, is going to list yourself. And there are a couple spaces here where if your case involves, for example, you and your partner are suing your landlord. If you are doing business under a fictitious name, like I operate as No Research Studio, I would use that form there. Basically anytime there's a complication to how these people are being bundled, you want to pay attention to those things on the form. Same thing applies for the defendant. And I'm going to talk about a couple situations where that can get kind of tricky momentarily. But as you can see, like this is just very much like, who is this person? Why? Here's this part where, of course, where it's asking like, have you notified this person that you intend to sue them? And you want to be careful too to make sure that you're filing in the right courthouse. So you want to file your paperwork in the courthouse that typically is local to where the person lives or does business, as you can see right here. But yes, this form is available online. It's something you can consult. And I'm going to skip over to the Small Claims 104 form. Essentially, once you have filed the SC 100 form, the court is going to receive that. You have to drop it off in person. They might have set up an e-filing system because of the pandemic. I haven't experienced it differently. But essentially, once the court approves your case, accepts your case, takes your paperwork and says, this looks all right to us, then you're going to need to take a copy of that paperwork and distribute it to the defendant. You yourself cannot do that. You can have anybody who is technically a neutral party in that dispute deliver the form. So you have a friend who likes conflict and wants like $25, like you can have them do it. I recommend using a service agent because often they are people that spend their entire life sleuthing people out. And if you have a defendant who knows that they are going to be sued, they might be taking extra steps to avoid you in particular. And they are also going to avoid that service agent. If you talk to service agent, they have seen a lot of wild stuff and they have a good sense of how to find people. And they will often give you information about what is going on in that person's place of business. And so, for example, if you are suing someone that operates like a franchise like AT&T, and you're suing that specific business, and suddenly they appear to be closed every time you go there, the service agent might actually stake out that store and figure out what's going on, so you don't have to be there. And that can be very handy. Again, this is a form letter. Read it closely. I'm not going to go super deep into it now because a lot of it is on an individual kind of basis. The thing that you have to recognize, though, is for small claims court, substitute service, which is when you give someone these documents who is not the individual you're suing. So say we're back at that AT&T store and there's like a manager there. If that person is not the registered agent that controls that business, giving them the forms is an example of substituted service. The court will very often reject that. You don't want to do it. You want to make sure that the service agent or the sheriff or your friend is hand delivering those papers to the person you're suing and that they are signing that document and then it gets returned to the court. And that is what allows the judge to say that everybody in this lawsuit understands that the lawsuit is occurring and that they have taken like adequate steps to prepare themselves. I mean, as you can see, this part of the process is extremely boring, lots of paperwork, but don't make mistakes. It pays to be meticulous. What you're doing in small claims court is just showing the court that you have taken the time and consideration to put together a compelling set of documents that show that you did your job, that you were being attentive, that you cared, and you just want things to be resolved, right? One way that you're going to be asked to do that is know who, well, I should say what and who you're suing. If you're suing a business, you're going to name that business. Let's say it was an LLC. You want to say the name of the business LLC at this business address, and it should be the address that they have legally registered under. You're going to want to Google that business and find out their legal address, their legal title, and the registered agent who is responsible for handling and receiving their legal mail. You're also going to want to make copies of everything if you are planning on going to court, and you basically should have enough copies for the judge, for yourself, and for any of the opposing parties, right? And there are going to be situations where, for example, you are suing two different businesses, or you are suing a group of people because there is a dispute among all of you. Every single discrete party needs their own paperwork. But it's up to you to provide that. Otherwise, it's not going to be recognized by the court as evidence. So like I said, if you fail to name all parties involved, if you fail to properly identify the corporation they represent, if you list inaccurate contact information, and that includes their address, you can basically jeopardize your entire lawsuit, because the court is going to receive those papers and be like, you didn't do a good job. You weren't meticulous enough. You don't care enough about this. You're being lazy. Why do we need to hear this? And that's not what we want. So I would say that the most painful, annoying, excruciating part of small claims court is serving the defendant. And it's precisely because the court does not accept substitute service that there's a particular difficulty, because you have to be able to locate that person physically where they live and serve them the papers. Not necessarily where they live, but it needs to be proven that it's them and that they are the ones who are signing that document. The court, again, is not going to hear your case if you don't have the appropriate kind of service and you can demonstrate with your SC 104 form that the individual you are trying to sue is the one that received it. As you might imagine, the kind of person who finds himself in small claims court getting sued might not want to be sued, and they might do a couple of desperate, weird things in order to finagle their way out of that. If somebody is serving that person as like a service as a service agent, or they're a sheriff, and that person basically answers the door, and the agent finds out, can confirm, because they say, oh, I'm so-and-so. I am Jared Fulby. What do you want? And then they try to give them the papers, and that person says, I don't want it. That the court will recognize that situation. Like they will, the person who's a service agent will say, I tried to serve on this date. I talked to this person. They refused to sign. So that's a totally different situation that is kind of on a case-by-case basis. Like I said before, I do recommend getting a service agent. They can be expensive if the person you're trying to sue is elusive, but you also have the option of saying, if you have the money, like, okay, I'm willing to spend a couple $100s to actually locate this person so that we end up in court, because I know the court will demand that I get that money back. We're going to talk a little bit later about the kind of options you have in terms of settling in or out of court, but I would just basically recommend in either case that if you have expenses that are tied to pursuing this person, keep track of them and don't be afraid to accrue them, as long as you have the capital to kind of forward the suit. And I guess that's kind of something to acknowledge from the jump, is that these cases can be expensive and they require an investment of your time and money. So I basically recommend that everyone collects evidence in advance. And so you want to have a really good system for determining, okay, like what records am I keeping of the various interactions I'm involved with as a freelancer or as a worker, et cetera, as a business owner sometimes, because while we all want to believe that every situation is going to have a written contract, and many situations legally will require a written contract, especially I believe the amount is like $1,500. It's the statute of frauds. So yes, which basically says like you need to have a written document or some kind of recordable media that shows that you enter this agreement, because the amount in question is high enough that we want there to be a recording or document that proves it happened. So again, you're going to want to keep everything: contracts, pay stubs, receipts, emails, even photographs of work you've done, or ways to kind of track and attribute like labor back to yourself. Really important. And then again, you're going to want to bring copies of all that for the judge and all the opposing parties. If it's a photograph or something that's a bit ambiguous, you're going to want to label that piece of evidence and provide some kind of brief contextual description that says, oh, this is where this person hit my car. This is the rent check I wrote to the landlord. This is where my roommate punched a hole in the wall. This is the article I wrote for this publication that they owe me payment for, stuff like that. So if you go, the California court system has this PDF, it's 2 pages online, that gives you a little bit of background about evidence. Unlike other court cases in small claims, there's no pretrial discovery, so you're not going to exchange evidence before your hearing date unless it's pertinent to the negotiations or mediation you enter in the phase where everyone has acknowledged that there's a lawsuit happening, and we'll talk about that shortly. But just some like quick rules, basically. People and things, documents, photographs, etc. With people, you want to get that person's consent, and you want to have a conversation with them before asking them to come to court about what their responsibilities are. There's a different set of expectations that placed on that person. I kind of don't recommend using witnesses in these kind of court hearings because it's kind of adding length and time and a kind of maybe third or just an outside perspective to a dispute that's usually between 2 or 3 people. In most cases where a witness could help, what you really want is just evidence that in writing or some kind of documentable form that they hold a view that is in accordance with what you're trying to say. So let's say that you work with somebody that was there when you performed the labor for this company, and they don't feel comfortable going to court because they don't want to have to face this client that you share or something like that. You can just get an email from them that outlines their side of the story. And I think it simplifies things and kind of moves things along, and the court will appreciate that. So the thing with evidence that you're really trying to do is build credibility, because often when something goes to small claims and there's an actual dispute, it means part of the story is missing. So let's say that you had an oral contract with somebody. It really comes down to the evidence that either party can furnish the court with that lets them know that their side, their perspective is the one that the court should trust. And what you want to have happen is that the court is no longer looking at you as a person, and they're looking at the evidence you provided that basically shows without your involvement, you're just bringing it to the court. It has nothing to do with your position. It has to do with basically the facts that are elaborated by that evidence, that your side is correct simply because you have the evidence that shows it. So the court uses evidence to assess a credibility. And as the plaintiff, you want to show by organizing your evidence and communicating in a neutral professional tone that you have a credible complaint, right? You want to basically be non-existent. You want the evidence to be the primary, the main exhibit, put a pun in place. So if the party you're suing acts in irrational ways and creates evidence that calls into question their own credibility, that's the prize, right? So if, for example, you had a client and they said that they wanted to pay you $2,000, it's in an email, you have it all laid out, you come back to them, they ignore your email, you send them the demand letter and they receive that but still are ignoring you, you serve them all the necessary paperwork, including the SC-100 form, and the SC-104 form gets submitted to the court, and then they come into court and say, oh, I never received a demand letter, or I never received this email from them letting me know that I owed them money. That's not going to look great because the court already has enough information in place by you filling out those forms and producing the demand letter that it's just going to show that they are not trustable, and that is just going to basically push the conversation in an entirely different direction than the judge hearing both sides, right? And like I said, the court is not going to sit there and try to be super diligent. This is not a larceny trial. This is not a murder trial. We're talking about less than $10,000. They are just trying to get to the point where things are indisputable as soon as possible, right? So your hearing date, honestly, if you've done your homework and you have all your paperwork in place and your hearing date is coming up, it's very, very likely that the person you're suing is going to want to settle out of court. I think I would say that everyone who's a lawyer would agree with me. Most cases that involve some kind of financial dispute, people don't want it to make it out into the public, and they don't want the court to find that they are not a credible business. That can really damage their reputation, and it could cause them to lose clients. It can have a lot of, I would say, far-reaching and less obvious effects. And so part of the reason people get a little thorny when it comes to legal issues is because they don't want their reputation damaged, right? But I would also say that if you have to go to court, remember it's an elaborate performance. You want to arrive early with your documents organized. You want to be ready to circulate those documents. You want enough copies. You want to be dressed appropriately. I would say somewhere between professional and business casual is usually all right. But you want to show that you're there for a business reason. It's not emotional. You have no personal vendettas you're trying to work out. You just want the money that you're owed. And things might get weird. And this applies to the negotiation process or any type of mediation process, but don't let that unnerve you. You want to remain firm, professional, neutral, and basically resolve to get your money. Let the judge be the person who goes through and goes in the back and forth and elaborates what the rules are and who's talking and why. And you will do yourself a favor if you don't directly address the other party. Talk to the judge as if they have all the power, because they do. So you will show to them that you are compliant, that you're credible, and that you have evidence ready. And that means that you're following procedure, which is the most important part, right? The court is a procedural system. They want to know that you're following their rules and that you understand them. And that's how you do that. Dress up, arrive early, be ready. If you've been paying attention to what I'm saying, and this is just a kind of classic legal truism, you really want to let your client create the case against themselves, right? In any situation when there's a dispute, it's better if the dispute can kind of be cut in half and the judge can look at it and say, okay, there's this happening over here, this is happening over here. The scope of this case is this issue that seems to be falling squarely in this corner. This individual over here performed all the work that they promised to perform. They have done a good job of evincing to the court that they did their homework, that they have recorded everything, that they have the documentation necessary to prove their their point. Even if there's holes in their case, it seems like this individual over here has not exercised the same diligence and might even be in denial about their position. And that is ideal for a number of reasons, which we'll get into shortly. And so now we can talk more about this idea of the indisputable defense, because basically what I'm asking folks to do is allocate all of the responsibility, the burden of credibility, and the burden of proof onto the opposing party. You want to walk in and have basically all your paperwork filled and all of the main points of your argument set out so that the judge has to do as little work as possible, because then the dispute will no longer be about you. And so just a kind of idea of where this idea of indisputability comes from, as the court tries to resolve your case, it will search for points in each party's respective argument that agree with each other, where you have moments of concurrence, which means if both you and your former client agree that you performed the work, the court is not going to want to figure out if it's the case that the work actually happened. They're just going to assume because you guys agree on this point, we can zoom the scope to here. And then if the court finds out that actually what you're disagreeing about is, let's say, you believe that you are owed $2,500 and your client says that they only owe you $2,000, something to that nature, right? Then that's when you're going to try to basically push the conversation towards, okay, well, what do I have in my pocket that shows that my amount is what I'm owed? And you also want to pay attention to how you're demarcating how you're owed that stuff, right? So like if, for example, you had to travel, complete the job, and you want to tack on your gas mileage, you're going to want to have those receipts in place, not only because you're going to get extra money, you're going to get reimbursed, but you're going to show the court that here's the evidence that I produced this labor, right? And then again, when a party submits evidence that undermines their argument, which makes their story not true, which draws their credibility into question, or they make statements that contradict what the court is able to rationally conclude, and we can talk a little bit about that later, they lose credibility. The thing that you don't want to do in court is like basically perjure yourself. If you come in and all the evidence that each party is able to bring together suddenly reveals major contradictions in what you've said, you are very likely going to lose that case. And you also want to prioritize evidence that's gathered from neutral witnesses or the opposing party themselves. Again, we want the dispute to be away from us, because then you're going to place that party in the awkward position of agreeing with you, which would be great, or they have to explain the contradictions inherent to their story to the judge, and that's just not a great position to be in. And then the reason why we want that is that once something has become indisputable in the eyes of the court, anyone that tries to change that or to undermine what the court has already decided is the case is putting themselves in greater legal jeopardy. And to give you an idea of what that looks like, if let's say in the course of the lawsuit, you are only asking for $1,500 because you and this person cannot reach an agreement about the amount of money that you're actually owed, and you manage to find a document that just shows that their standard rate for the job that you did is actually twice that, it's not going to look good if you have an email that shows that you did the work in question and that you're settling for less than what you're owed, and that person is still denying that. They are going to put themselves under greater scrutiny, and they are also, if the case goes in your favor and they are unwilling to accept the outcome, they are putting themselves in a position where they are open to kind of like a defamation suit, right? If they are going to dispute what the court found and they don't have a rational basis for maybe appealing the decision, they are no longer respecting the kind of boundaries established by the court. And that is when more complicated lawsuits that are not small claim suits pop up. If you accept this kind of outcome that the court is looking for, this indisputability, and that the party that is going to put themselves in the place of contradiction is the one that's most likely to lose, you're going to make the best argument, because you're not going to focus on explaining every detail of what happened. You're going to focus on the moments where they are not being consistent or honest, and that's really all the court cares about once you've established what you're owed. So again, you want to let the opposing party fight against themselves, because if they're lying or fabricating, evidence will show that, and the judge will not be pleased. Some kind of footnotes on this: the court isn't going to say, "Oh, Evan, you provided the most evidence. It's clear to us that like you were wronged." They're going to just say, "We rule in favor of this plaintiff or this defendant," and that's really important, because you can't go around and say, "Oh, I was right. I beat this person in court." That's actually just kind of a misnomer. The court decided that you deserve this award, and there can be other disputes that happen down the line about the narrative that you and the opposing party established to explain each side of the story. And which is why you need to be careful once you settle the dispute. You don't want to go around and keep the kind of dialogue going, because the court basically is saying, and also if you settle out of court, that the settlement basically says, this is no longer a problem. I'm no longer going to bring it up, and I'm not going to keep drawing this tension or this problem out, right? The idea is that you're ending it conclusively and permanently. So yeah, maybe consider not talking about it. So a quick distinction between settling in and out of court. The good thing about settling in court is that in the eyes of the law, the court has favored your argument unless defendant countersues, which they might. That's always a possibility. It's a risk that it is entailed. The judge will award you full or partial damages depending on the evidence you're able to produce. So basically, legally speaking, you have prevailed, but it's not that you won, it's that the court sided with you. The bad part is that serving the opposing party can be impossible. And so even if you get to that final point where you have all your evidence in place and you've been trying to serve this person, they might disappear, and you'll either either have to drop your suit if you run out of time in terms of the kind of statute of limitations, or you can refile. All these things cost time and money. So basically that person can succeed at draining the clock and wasting your money. And on top of that, you can't receive more than the money that you claim to be owed and that you can prove that you're owed. And so that's a positive part of the settling out of court process, which we'll talk about in a second. But again, even if the court sides with you, the opposing party can still choose to avoid paying you. There's plenty of legal obstacles they can put in the way to buy themselves more time. And also the small claims court, because it is a limited jurisdiction, specialized court, doesn't have the power to really do much. They can garnish that person's wages, but that means that basically you have to go and find and serve them again and begin a separate legal process to begin that. Settling out of court, which I think most lawyers would recommend at this point, you can hire lawyers so they can participate in that process. They can't go to court with you, right? You can negotiate for more money than you're owed. Like, again, most people don't want to be in the position of losing in court publicly, or they don't want to have any kind of ding against their business or their reputation that could affect how they're doing financially. And you can include further legal protections for yourself in the settlement. So if you want, like, basically like a, don't contact me, kind of maybe an enhanced NDA that circles around the lawsuit or the dispute, these are things that you can include in that document, usually a lot of ease. And ultimately, you don't have to go to court. It rules. The bad part is you will probably not be able to speak about your dispute publicly. And that can be very emotionally draining or emotionally affecting, because often when you're in the position of having to go to court, all the way to court, if you will, to get money that you're owed, it could be an emotionally draining process. And we all want to talk about it and talk about how uncomfortable, dehumanizing, and embarrassing the whole thing was. And also the same kind of protections that could be applied in your favor in the settlement can be applied to the defending party. So they might be willing to pay you a considerable amount of money for the added protection that you pretend like this never happened, right? And again, clean slate, clean mirror is kind of where we want to end. And the reason why I kind of use this mirror image is something that I was working on in the studio when I was doing a lot of the research behind my own small claims kind of situation, is it just reminded me a lot of what the outcome of that process is. So if you look at this mirror, it's true that the mirror is kind of cleaned off of all the stuff I had on top of it, but the detritus is still in view. And the reason why that's important is because the court is simply going to try to restore things to what they were. And when we're talking about damages are simply things that you have basically like proof of expense in this particular type of court, right? So if you have proof that you're owed money, if you have proof that you're owed reimbursement, if you have proof that the money in question has not been delivered to you, even though it was promised, that is what we're talking about. So the court will attempt to restore things to what they were before the suit. And the idea is that the party damaged in the dispute should be compensated, little typo there, according to what they lost. And you can't ask for more than what you lost. But conversely, once the party that has been shown to be responsible for the damages, like, they have to settle their debts at that point. And the court is going to have basically a snapshot of the different kind of financial damage that they have caused. And this is precisely why you need to keep your receipts, and you need to have a kind of strong narrative of why they owe you that money alongside those receipts. And like I say here, literal and metaphorical receipts are your friend in these scenarios. And these are just immense credits for the work. And now we can kind of break into what I hope is the Q&A part of this conversation. So I'm going to stop sharing the screen, and I'm also going to stop yammering at you for a second.
No problem. I think one clarification was that though you cannot ask for more than what you lost, you can still recoup things like costs, court fees.
Yeah. So these things are different. So because you're going to incur legal fees as you go through the process. So if you start and you say, I need $1,000 that I'm owed, and then you have to pay to file your case, and they have to pay a service agent, and they have to pay a lawyer to consult, those things can all be pushed back into your suit, right? And so if you go in and let's say you have to settle out of court, that lawyer that you hire to help you through that process is an expense that you can charge to that person. And this is precisely why people are going to want to settle as soon as possible, because the longer that the suit takes and the less evidence they have to show their position is true, the more legal fees they're going to incur. And let's say, for example, that you're only able to prove that that person owed you $500. Once you try to settle with the lawyer and that lawyer charges their fee, you're not going to be in the position of only paying $500, right? And so it's in the interest of both parties to settle as quick as possible, which leads me to one of my points I didn't put in the slides, which is if you are going to settle out of court and you are going to make a kind of demand for money, go big or go home. Because even if you are picking an absurd number, you need to let them know in the first instance that you mean business and that you're willing to kind of be not necessarily absurd, but that your time and your money and your value is not debatable, or that they don't get to choose it for you. And that is actually a crucial part of the negotiation process.
So we had another question kind of come in. Can you include the time it takes to pursue the lawsuit as a reimbursable cost? Evan, do you know the answer to this?
The answer to that is no. And that's important because the question is how you prove that, right? So it's really frustrating to find out that you are now personally responsible for getting payment, but the court doesn't believe itself responsible for restoring that labor, right? And the idea and the restoration is not that they are making up for things that happened during your personal experience with the lawsuit. it's doing what it can to take that particular agreement, limited to the scope of the agreement, which you're having a dispute about, so a contract or oral agreement, and trying to restore things to what they were before that, right? And then it's not just court fees. I would say it's broadly legal fees. And so that can be fees that you pay the court, fees that you pay to a service agent, fees that you pay to a lawyer. Now, there's some wiggle room here, because any consultant you hire to advise you on these legal issues technically can be included, but the opposing party might try to dispute those things, right? So say, for example, you wanted to hire someone you know that isn't a lawyer per se, but they review contracts. You can say, oh, I had to pay for this service to review the contract, and then they found these things for me in relationship to this case, and here's how they're instrumental in that decision. So you're going to need to reimburse me for their fee, stuff like that.
I think a good thing to bring up maybe is, how do you find things like the legal name of the defendant, and like what would be a way to research that?
To go find the legal name, you just need to use Google, right? And there's a number of sites that are going to have to list that business's legal name. For example, if I wanted to sue the California Lawyers for the Arts, I could go on GuideStar, which is a nonprofit kind of listing site, and search for that name, and it's going to give me the legal address and the registered agent on those sites. But that, again, is going to be case by case, because not every person that you're suing is going to have a registered business and need that, and they might have a fictitious name. So again, case by case. Are you saying that in the negotiation for out-of-court settlement, one can or should ask for more than the small claims court could deliver if one settled the matter in court? So yeah, basically, let's say that the reason why you didn't get paid is that the person you were working for said a racist statement and you had a disagreement, or let's say you had a disability and they made some kind of statement about your disability that you felt was offensive, and you said, I can no longer work for you, but I'd like to settle up. And let's say you had an email where these statements are kind of like put out there, right? If you have proof that shows kind of like malice of that degree, that person is probably not going to want to settle that in court. They're probably going to want to settle out of court, and they're probably going to want to pay you a fee to remain silent. And so, like, legally speaking, this kind of idea that you do or don't do things for somebody according to what they want is performance. And so if you are going to perform silence, if you are going to perform as if this event never happened, it makes sense that you would try to recoup some kind of fee, right? And so, yeah, it means that you can be settled for more. There's no limit to what you can get from that person, because it's up to them to determine how much they want to spend to keep things kind of out of court. And they are more than welcome to go above $10,000. My neighbor broke a window on my house when tearing down a house without a permit and throwing the structure into a dumpster about 3 feet from the window. I recovered a piece of siding from my property directly from below the window. When I asked for payment to replace the window, the owner said, prove it. How can I create an indisputable defense? Okay, this is a situation where email is your friend, because I feel like what you have to do in cases like these is get that person to talk, right? And so this is this legal principle that's often stated, which is like, let the person basically hang themselves. And so the problem that person is creating is that they believe that the onus is on you to prove that the window or this thing that happened is their responsibility. I would let other people maybe talk to them. Like if you have a neighbor that's kind of act as a mediator, or if you want to get like there's other services that do this. It's not just the California Lawyers for the Arts, that they can enter some kind of mediation between the two of you. Getting that person to commit their version of the story to paper is ultimately the best step. And then from there, if you can find other witnesses that can like validate your like chain of events, that's really good. And so also, like you're saying that like they were tearing down a house that didn't have a permit, you can ask them to provide the permit in court. You can take pictures of the house to show that it's something torn down. So if it's the only house on the block where there's work occurring and there is this like kind of detritus that's around it, they have to prove at some point that it wasn't theirs, right? Logically, we can all say that like it didn't just magically appear there, and it's very likely, not indisputable, very likely that it came from the house. And so it's just that kind of thinking that you need to train yourself to do. I feel like there's a number of court cases that happen because there is some missing piece of information, whether it be a contract or a video that could like resolve all this. But ultimately, it comes down to providing as much evidence as you can possibly gather to just prove that you're credible. Oftentimes in a small claims court hearing, it's really not about like the court firmly deciding like we have all the evidence we need to prove this is the case. They're going to say there's enough evidence for us to move in this direction because it seems the most fair, right? That's a major distinction between small claims and your, again, like a murder trial. There's not the same thing of like innocent until proven guilty. That's not what's going to happen there.
Once you win a case, how do you actually collect the not the reward, but whatever?
Yeah, no, but this is the problem.
Remedies.
Yeah, no, it's your award, your fee. And the problem with small claims court is that it's kind of toothless. And so even if you win, there's all kinds of other procedures that you need to engage in that are not going to necessarily directly put the money in your pocket. And this is, again, the small claims court does not want to hear your case. And so you should try to settle outside of court and be very aggressive with your demands prior to that hearing, because that is the situation where you're most likely going to get what you want, right? I have never been in a situation where I've had to try to get the court to help me collect or garnish a person's wages. But everyone I've talked to that's had to deal with that has a very similar story, but it didn't work out because it's a low priority. And again, it's less than $10,000 to the court. They're basically going to be like, do you want to keep wasting time pursuing this, or do you want to make money elsewhere and, suffer the loss and move on? There's two questions that are very similar, right? And so like the insider baseball question to both of these, which is like, is small claims court worth it? And also like, is it better as an arguing tool? I would say that like, it really depends on small claims being effective depends on what you want from the situation. If you want money and you want to have remuneration happen, you're probably going to want to settle outside of court, unless the person that you're suing has sent you the settlement that is really, really aggressive. Maybe they're willing to pay you $50,000 to never talk about it again, but they have all these really precise stipulations that if you break them, you have to pay them back the money. That would not be an ideal situation if you feel as though you can't uphold that part of the bargain. I would say that small claims court often, not always, but at its best is that bargaining tool. Because, for example, if you manage to serve them, everything goes great, and all you really want is your $2,000 and to say that you got the money you were owed, and that person no shows, which happens consistently, then the court is automatically going to decide in your favor. So it really depends on the person that you have this dispute with and their kind of nature and their temperament, and go from there.
And this is, of course, always a great place for us to plug California Lawyers for the Arts services. Our mediation services will help you and another party come together and try to solve a dispute without going to court or without doing small claims. So if you do think there is a possibility of coming to an agreement without doing these extra steps, please use our mediation services. We have huge success with this program, and maybe instead of going to small claims, they'll agree like, okay, well, let's try mediation first. That always happened too.
And the other thing I'll say is that technically, like the city of Los Angeles offers its own mediation service. In my experience and estimation, you might be better off not using it because they are not as quick to respond as an organization that is essentially set up to handle that type of mediation request.
Yes, and mediation, it's like one of our bread and butter kind of programs.
Yes, mediation works because the court is in the background. But beyond that, what's great about mediation is that you can involve a lawyer, and that lawyer can like basically take the heat that you're putting on that case and turn it really up, because the lawyer is going to find other things that are happening in the background that person might not want to become public, right? Or they might emphasize aspects of the communication that's happening between them that you didn't think about, that give them, the person you're suing, a sense that they would be in jeopardy if they did not comply, right?
Thank you, everybody, for coming.
Thanks, Renee, for having me. One more point that just came to mind is that people should always remember that often your first consultation with the lawyer is free. And if it falls into the realm of small claims court, like they might just give you some really, really cost-effective, because it's free, advice. And so I would also recommend, as part of the research you do to build your case, speaking to as many lawyers for 15 minutes as possible. It's not going to cost you anything. They're going to give you really useful information, especially if it's a lawyer that has some kind of practice or specialty associated with the thing that you're dealing with. So if you have a labor problem, talk to as many labor lawyers as you can. If you're an artist, talk to as many arts lawyers as you can, because they're going to give you all kinds of background info that you can, it might not directly apply to your case, but you can add it to your mediation and dispute kind of resolution process. That's what I'll say.
Yeah. And actually, in addition to our mediation services, we have a lawyer referral service. Our lawyer referral can help you in many different disciplines. It is a bit more of a bigger question consultation that would not be free. But let's say maybe you're impacted by COVID and you don't have a lot of income right now. Don't let that hold you back from using our services, because it is a income-based program. So it might be a lot cheaper than maybe it normally is. And if you're not based in the state of California, we're happy to refer you to other volunteer lawyers for the arts. They exist in many different states. But we'll try to help you as much as we can. Yeah, Evan, thank you so much for joining us tonight. It was such a great presentation, and thank you for sharing your slides and your time with us. All right, well, have a great evening, everybody.